Yeah, and as it relates to the Chauvin trial, which we contrasted and compared during that trial, obviously George Floyd was an intended target of Derek Chauvin. So the same analysis would apply there. So we know that Derek Chauvin was found guilty of third-degree murder. I would expect, even though he was also found guilty of the higher charge of second-degree murder, which has a 40-year max, that his attorney should appeal that and get that conviction expunged as a result of the Noor decision. Would you agree with that?
Absolutely. If I was Chauvin's trial lawyer, I would go to town on that, simply because it makes a lot of sense to represent your client in that way. Now, with that being said, if we're talking about what it means for Chauvin, I don't know if it's going to move the needle too much. He's been convicted of a higher offense. This is like a lesser included offense. So it might not change the outcome so much. But if I was his appeals lawyer, I would go to town on it, and I would try to take it as far as it can for the client.
Yeah, I mean, it's inconsistent with this Supreme Court ruling, so it really academically it should just disappear. But you're right, he's got a higher conviction, so the net effect is really zero. How about this? One more question. We have the the aiding and abetting charges against King and Lane and Tao coming up. Any impact on those?
Yeah, if I was their defense attorney, I would point to this and I would, show the lack of intent, lack of motive to be able to gain that, and I would use that in their support. I also would really try to push the prosecution to try and prove a third degree charge there, and the reason is it wouldn't stick. So I would try to frame this as that simply because you'd get an acquittal for your client.
Yeah.